Deputy Clerk. Now, Deputy Vanabachik, please.
And I'm glad to speak for Labour this evening on this important bill, and to speak not only as the Labour spokesperson on children, but as a member of the Joint Oireachtas Committee on Children, Disability, Equality and Integration. And I do welcome the fact we're debating this bill today, and I do acknowledge that it's a day I think we'd all hoped would be a landmark day for the rights of adopted persons to access information, to access birth information and to access their identity right. And I do absolutely appreciate, Minister, your commitment to ensuring that, and the fact that there is progress. There is significant progress being made in the bill. But I would share Deputy Kathleen Funchions' reservations about aspects of the bill, and in particular I share her disappointment that some critical recommendations of our committee in our pre-legislative scrutiny report have not been adopted in the bill. And I do want to pay tribute to Deputy Funchion, who steered and chaired our lengthy deliberations at pre-legislative scrutiny stage. And as she said, the 83 recommendations we came up with were based on the hearings, the extensive hearings conducted, and I joined the committee having been conscious that already there had been quite extensive consultation, but I participated since July, and since my election, in more extensive hearings. And we did hear from so many stakeholders, and we did really engage very closely with the draft heads, and our recommendations we believed to be really robust. And I do appreciate that some of them have been accepted by you, Minister, but I want to address three critical ways in which our recommendations were not addressed in this bill, and therefore I think it's on the basis of those in particular that many of us will be disappointed, many of us who are members of the committee, and many of those who received our recommendations well, who were stakeholders and who appreciated the recommendations, I think, share that disappointment. And the first point is really that critical issue of access to information. Is this indeed going to be unrestricted access as was promised, and I think as people had hoped, or is it in fact conditional access? And I think we're all disappointed on this side of the House that the access is still remaining as conditional. Yes, there is a great step forward from what was previously provided for in other iterations of this legislation, but there is still a condition, this mandatory information session. And I want to ask, Minister, why we can't get beyond this. I think it was very helpful of you to set out the history, the long history over many decades of this state grappling with how to provide for information rights for adopted persons. I think perhaps the one thing you didn't say is that there's been, just in the very recent past, attempts by the opposition, including my own party, to bring forward legislation. Early in 2020, we brought forward the Adoption Information and Tracing Bill, which would have inserted a new Section 86 into the 2010 Adoption Act, a simple mechanism to unlock the information necessary to enable adopted persons to access their birth certificates upon turning 18 by making traceable the connection between an entry in the Adopted Children Register and a corresponding entry in the Register of Births. Now, other opposition parties also produced very similar legislation, which again provided for simple unlocking mechanisms without cumbersome restrictions being placed on access. And it's clear, I think, not just from the history you've outlined, but also from the opposition attempts to legislate on this, that there is a clear cross-party intent in the Oireachtas to ensure an unfettered right of identity and of information to adopted persons. And I do want to pay tribute to the many individuals and advocacy groups, such as the Adoption Rights Alliance and the Clan Project, who also sought to do this and who helped us with this and who gave evidence before our committee. And I think, we also looked at legislation in neighbouring jurisdictions. We looked at other European countries. In Northern Ireland, we're conscious anyone aged over 18 has the right to a copy of their original birth cert since 1987. In other jurisdictions, for much longer. And yet, we're still seeing in this new bill, in the provisions that we've been presented with, we're still seeing retention of a conditional right of access. I'm conscious that I worked closely with your predecessor, Minister Zappone, on trying to trying to ensure a right of access to information. And we heard constantly, both in briefings with Minister Zappone, but also on the floor of this House and the Seanad, that that there had to be a balancing of rights with the right to privacy of mothers, that the right to information could not be provided for in an unconditional way. And we really examined this very closely in the committee. And I looked again just today at what we said in the committee, and we made the point that, based on the evidence we'd heard and the expertise of those before us, that that the constitutional balancing could be addressed in other ways, that it wouldn't be necessary to provide a mandatory information session. And indeed, we said very clearly that, a mandatory information session was the inclusion of this for persons whose parents had registered no contact preference. This still remained, it still meant that this would mean that adopted people whose parents had registered this no contact preference, I quote, will be singled out for different treatment and a targeted warning about privacy rights. And that this was seen by some witnesses as compounding misguided fears about adopted people and perpetuating injustice. We proposed an alternative. We said that there would be a clear alternative that would be appropriate to include would be the sending of the correspondence, the information about the no contact preference by registered post. And this, in our view, was a way of ensuring a balancing of rights, along with the other measures. And indeed, Minister, you said, as you said yourself, there are other measures too there in the bill to safeguard privacy rights of mothers, namely the age limit of 16 plus, the counselling provision, and the provision of information in some way. Now, you know, what I suppose is the big question for I think any of us who've engaged with the process of pre-legislative scrutiny is why then do we see retention of this mandatory information session? And I'm looking at the wording of the sections in the bill, and I think it is a mandatory information session. There's no other way to describe it. I'm looking at section 7, which says that, you know, the recipient body shall comply only where it is, in the case of the no contact registration, only where it has received a notification of the completion of an information session. What is that information session to comprise? Well, we know when we look at section 17 that it's very clearly set out what the information session will be, and again it's still referred to as an information session. It's referred to as a session which is still to which is an information session held between the adopted person and a designated person, and we know that that's an employee of TUSLA, the Adoption Authority, at which the designated person informs the relevant person of their entitlement to get the birth certificate or birth information, the fact that the parent has stated that he or she is not willing to be contacted, and crucially, the importance of the relevant person respecting the privacy rights of the parent and the preference of the parent. Why does that have to be imparted in an information session? Why can that information not be imparted through I think a less, I suppose, perhaps an easier mechanism, the sending of registered post, with the backup of counselling or supportive meetings where desired by the adopted person? I suppose, Minister, that's my question. Why could we not have seen an alternative mechanism put in place rather than this targeted warning session? Yes, I accept, and I think we all do, it's no longer needs to be held in person. It can be by way of phone call or virtual call, and that's a welcome change. But again, I think from the perspective of the people who are contacting us, adopted persons, but also mothers and other stakeholders, it's seen as still a paternalistic approach. It's seen as still representing a condition upon access which is not one that is desired or welcomed by adopted persons. And indeed, we've seen some very really disheartened and disappointed language from those who've contacted us. Some saying that they feel it's offensive that our laws will still require the information session. They feel it's unnecessary that it has to be explained to them in this verbal fashion, that they must respect the will of the woman who gave birth to them when this much is already patently clear. I think, you know, we're hearing real disappointment, real disheartenment and real frustration at what appears to be a grudging step forward, rather than the big step forward that I think we'd all hoped we'd see in this legislation. And, you know, again, Minister, I would ask that you might look again at our report, particularly pages 23 and 24, where we set out so clearly our rationale for moving away from a mandatory information session. And I know I've spent some time on this, but I do think it's perhaps the most disappointing aspect of the bill is to see retention of that and to see the language still being used in section 17. And again, I speak with a heavy heart. I really had thought we'd moved beyond this. I had thought that the arguments that we'd heard over the years about balancing of rights should now be taken in a very different context in 2022. And we should be able to build on the experiences we've had and the different iterations that you've outlined so clearly that we've seen over the years in attempts to legislate on this, that we should no longer need to see this sort of mandatory condition. I would just ask this question in concluding on this point, which is what happens if an adopted person says, no, I'm not taking the call? You know, they don't have access then to the information. This bill does not provide, as I think we'd all hoped and expected it would, it does not provide for a release of information in all cases. And that's the disappointment, I think, that is felt. And, certainly I know others will be bringing forward amendments. We in Labour will bring forward amendments on this. We'll simply be looking to implement the recommendations of our own committee, which was, as I say, the cross-party committee and specifically which was charged with undertaking this pre-legislative scrutiny. So I think this is the really important point, and I think there will be a great deal of debate at committee stage on the provisions around this information session, and particularly on section 17 and on the related sections 7 and 8 and 9 and 10. Minister, I also wanted to address the issue of illegal adoptions and incorrect birth registration information. And again, we'd addressed this in our report and recommendations 10 and 11 in our report, where we looked specifically at the definition and recommended that a change be made, that in our view, and again hearing extensively from those affected, in our view, the definition of incorrect birth registration was, I suppose, somewhat sanitised, that it should be amended to say instead falsely or incorrectly recorded. That the concern was that this seemed to reflect just an incorrect or a lack of correct information that was carried out in error. Whereas we know from extensive testimony over the years, we know that in fact there were false registration of birth, that this was done, in other words, deliberately and not just in error. And we believed, and again, we were hearing from many of the affected, that should be recognised in the legislation or indeed in the explanatory memorandum. And again, we suggested that the text in the explanatory memorandum should refer to the term illegal or unlawful adoption to clarify that the procedures for rectifying the register, which are very welcome in this bill, that they would apply to both those whose particulars were deliberately falsified and those whose particulars were merely incorrectly recorded. Now, it may well be, and I think you'll probably reassure us that in fact that application, the procedures for remedying the register will apply to both falsely or simply incorrectly recorded in error. So I anticipate that, and I can see you nodding, Minister. But I think again it's simply to reflect the lived experiences of those who were illegally adopted. And it is welcome to see sections 52 and 53 in particular, to see the legislation addressing this issue of illegal adoption. And, just to say again that I think we're all conscious of the serious difficulties that so many adoptees have had due to false registration. And I want to pay tribute to former Deputy Joan Burton, who spoke so eloquently on Sunday with Miriam just last weekend about her own experience as an adopted person, and who's been such a champion over the years of adopted persons and of information rights for adopted persons, but who in particular really took forward the case of those who'd been illegally adopted. And indeed, she and I in 2019 published legislation seeking to deal with this after the revelations of over 100 illegal registrations of births and adoptions at St. Patrick's Guild. And I also just want to pay tribute to the others who gave time to give their own public testimony of their own experience in the documentary on RTE in March 2021, which was so powerful. Who Am I? The Story of Ireland's Illegal Adoptions. And the contributors to that spoke about their experience of discovering, in many cases, many decades later as adults, that they'd been illegally adopted, the trauma and anguish that caused them. And one contributor very strikingly said they felt their life was built on a lie that they'd been told. So it's really welcome to see the legislation addressing their situation, but I think just when one hears that powerful testimony, it's all the more important that the reality of their situation is recognised, that in fact these were deliberately falsified records in some cases, that these weren't just clerical errors. And I think the language in the bill perhaps doesn't adequately reflect that. And again, that's what we found as a committee also. I wanted to just finally, in terms of the committee recommendations, just address a crucial recommendation which comes up a number of times in the report. It's recommendation 73, but it reflects an issue we had with the bill more generally, and as I say, it refers to quite a number of different issues in the bill. And this is the lack of an oversight or appeal mechanism. We called in Amendment 73 for the establishment in the bill of an oversight process or accessible appeal mechanism. We recommended that the bill provides for recourse to an ombudsperson or other process to ensure oversight of the application process, support for adopted persons and others in using the provisions, and an accessible and effective appeal mechanism. And we outlined at page 51 our rationale for this, but it comes up, as I say, a number of cases in the pre-legislative scrutiny. Because, for example, in head 13 of the bill, we had said that there was this enabled TUSLA, or the Adoption Authority, to make a request to a third party for information needed to assist in the process of tracing. But this is lacking an enforcement mechanism or some oversight. Now, I have to check to see if that's been addressed in the bill, but more generally, what appears to be lacking in the bill is a more general oversight mechanism or appeals process. And I suppose, again, I'm coming back to the mandatory information session, which is so contentious. What happens, I ask again, if the adopted person says, I don't want to partake of a phone call, I don't want to take this call? Is there any appeal mechanism? Where's the oversight? Where's the next step in the process then? Or is there one? Or are we simply assuming there won't be a need for one? And again, I think we had a concern about that on the committee, that the bill is lacking that, a clear outline for adopted persons and others of where they go next if the processes, the primary processes, we might say, set out in the bill, have failed them in some way. So, Minister, I hope you will take this commentary as a constructive criticism. What I wanted to do really was outline, I suppose, just three areas where I do think the committee has made some very robust and clear recommendations which would have greatly improved the bill, and where I think it's unfortunate to see they're lacking. As I say, there is much to welcome in the bill. I mean, I think all of us will acknowledge that, and we're very, very pleased to see it come before the House at this stage, to come forward so quickly in the term of this government, albeit so long overdue, given the long processes that have gone before. I think we're all conscious of the history of the stigma which prevailed for so long, which allowed for the incarceration of women and children, which has defined for far too long our national approach to adoption. We'd all be conscious that the primary legislation, the Adoption Act of 1952, enshrined a secret and closed adoption system, and as a result we have developed a secretive system, and in the words of Vivian Darling, former chairperson of the Adoption Board, this has ensured that adoptees have been kept in the dark as to their origins for far too long. And I really want to acknowledge your own commitment, Minister, to ensuring that adoptees are finally brought into the light in being enabled to access birth information. But I think also you'll appreciate the frustration many of us feel if we're still seeing some form of condition placed on access to information. I've spoken before about my experience of representing many survivors of abuse in industrial schools and other institutions over the years, and hearing from them just the really harrowing experiences, not only of being incarcerated and abused in many cases, but also of being failed by a state and that had simply failed to provide any sort of safeguards for children in their situation. And I think, there's still a feeling of many of those who are now adults who might have gone through experiences like that as children who've been adopted. There's a real sense of failure by the state, and we need to make sure that we're stepping up, that we're seen to really be addressing the needs of adopted persons in particular, but also of mothers who are failed too by the state, of those who were incarcerated in mother and baby homes. And we in Labour have called for full public inquiry into adoption practices in the state, to investigate the scale of illegal adoption, because we're still not clear about the scale of it, and to give more scrutiny, I suppose, suppose, to that practice which has been left in the dark for so long. And we must also reflect on all sorts of ways in which we're still failing women and children, in particular earlier tonight as we debated violence against women, in failing to provide adequate domestic shelters for domestic violence survivors, for example. So I think these are all issues which are very much intertwined. I want to conclude just by saying again, you know, it's great, it's very welcome to see legislation that will go some way towards meeting the real needs of adopted persons, their real need for information as to their identity, their need to access their birth certificates. But let's work together constructively at committee stage and report stage to ensure that the bill can be amended and can really provide for that full information right, that full right of access to identity that all of us want to see finally enshrined in our law.
Thank you very much, Deputy Patrick. Now, Deputy Murnane O'Connor.
Thank you, Count Cearla, and thank you, Minister. And